merely by calling a question a political question, the judicial review thereof may not cease automatically. It is ultimately a question of choice with the courts whether they would review or not review a political question. The doctrine of political question was evolved in the United States based on rigid separation of powers and does not strictly apply in India. Existence of unusual and exceptional circumstances justifying exercise of ordinance making power, and whether preconditions exist for ordinance making power, is not a purely political question. In Krishna Kumar Singh versus State of Bihar, action of the governor in issuing the ordinance in quick succession was disapproved. The constitutional fiction of political question should not be permitted to stand in a way of court to deny the nation the guidance on basic democratic problems. Avoidance of entering into political question may not be desirable but may not be resorted to because of expediency in the larger interest of public good. In this context, some of the articles of the Constitution of India speak of the satisfaction of the President in taking some specified action. For instance, power of the President to promulgate the ordinance, Article 123, or to declare national emergency under Article 352, or to take over the administration of state on account of failure of constitutional machinery therein under Article 356. In Bhutnath versus State of West Bengal, the Supreme Court refusing to hold the continuance of emergency under Article 352 subject to judicial review stated the question was a political, not justiciable issue and appeal should be to polls and not to the courts. Again, in the context of Article 356, in State of Rajasthan versus Union of India, Chief Justice Beg said, I quote, question of political wisdom or executive policy only could not be subject to judicial control. But then he placed a rider, no doubt, executive policy must also be subordinate to constitutionally sanctioned purposes. It has its sphere and limitations. But so long as it operates within that sphere, its operations are immune from judicial interference. Unquote. Justice Bhagwati joined Justice Gupta stated, I quote, it is true that if a question brought before the court is purely a political question, not involving determination of legal or constitutional right or objection, the court will not entertain it, since the court is concerned with the adjudication of legal rights and liabilities. But merely because a question has a political complexion, that by itself is no ground why the court should shrink from performing its duty under the Constitution if it raises an issue of constitutional determination. Unquote. As regards the President's power of assumption of the state government under Article 356, Justice Bhagwati stated, I quote, the satisfaction of the President is subject to one and cannot be tested by reference to any objective tests. It is not a decision which can be based on what the Supreme Court of United States has described as judicially discoverable and manageable standards. Further, the court cannot go into the question of correctness, adequacy of the facts and circumstances on which the satisfaction of the central government is based. That would be a dangerous exercise for the court, both because it is not fit instrument for determining a question of this kind and also because the court would thereby assume the functions of the central government and in doing so enter the political thicket which it must avoid if it is to retain its legitimacy with the people. Unquote. Justice Goswami, talking about the change in the state government, said, I quote, the judgment whether in truth and reality a particular situation exists or is worryingly imminent may be correct or incorrect, but it is a political issue. The court's jurisdiction is not political but entirely judicial. Unquote. In Maganbai versus Union of India, with regard to justiciability of the question of cession of some Indian territory to Pakistan, the majority stated that in the matter of a dispute as to the boundaries between two independent states, the municipal courts should be slow to interfere. However, in A.K. Roy versus Union of India, Chief Justice Chandrachud, commenting on the ordinance making power of the President under Article 123, doubted whether under Indian Constitution the political question doctrine could be invoked to deny justiciability to any issue. In S.R. Bommai versus Union of India, it was held that the judicial review may be avoided on a question of purely political nature, though pure legal questions camouflaged as political questions are justiciable. The court must have manageable standards to decide a particular controversy. The action of the President under Article 356 is a constitutional function and the same is subject to judicial review. The question related to extent, scope and power of President under Article 356, though wrapped up with political thicket, does not get immunity from judicial review. Even without characterizing a question as political question, the court may refrain from exercising their power of review on account of the fact that the question involves a matter of high state policy. In Hocost Pharmaceuticals versus State of Bihar, the court took the position that assent of the President to bills was not justiciable. The court also cannot inquire the reasons why the bill was reserved for the governor under Article 200 for the assent of the President, or to inquire into whether the President applied his mind to the question or whether there was repugnancy between the bill reserved for his consideration and received his assent under Article 254, Clause 2 of the Constitution. Can the courts intervene in the prerogative of the executive to commute a death sentence? Such a power is conferred on the President under Article 72 of the Constitution of India. In Kuljit Singh versus Lieutenant Governor of Delhi, the Supreme Court, after admitting a writ petition challenging the President's refusal to commute a death sentence, rejected it later on as there was no justification on intervention on the facts in the instant case. As regards the question whether or not there should be guidelines for the exercise of President's power to commute a death sentence, the court refrained from saying anything in this particular case. Dear friends, let's conclude the topic with what is the position of reviewability of political question in England. The question as to how far the courts in England would interfere with the exercise of the prerogative power of the Crown remains uncertain. Lord Dennings has said that since the prerogative is a discretionary power to be exercised by the courts just as any other discretionary power which is vested in the executive, merely policy making by the executive is not subject to judicial review. It is only when a policy is put into practice and it hurts the interests of somebody that reviewable question may arise.